So why is my ex's solicitor ignoring my evidence? Do you know, over the last 17 years of helping families through family court, I have seen a whole wide variety of reasons, excuses. I have seen fake emails being compiled by solicitors. Seriously, nothing shocks me at this stage. What else have I seen? I have seen the photocopier not work. I have seen evidence where pages have been missing, or where the evidence comes out and it's so blurry that you can't read it. I've seen it. I've had solicitors deny that the evidence was even sent across. So listen, the rules that you play with in family court are not the rules that you play with in real life. Evidence, and when I say evidence, sometimes that's attached to a witness statement, sometimes that's attached in a bundle. So let's just get the legal bits out of the way with first. So practice direction 27A, write it down, you're going to need it, is what should and should not be in the bundle. Whose responsibility is it to produce the bundle? FYI, the represented party is the party responsible for putting together the bundle. Actually, it's the applicant usually, but if you're a litigant in person and you happen to be the applicant, then it's usually the responsibility of the respondent, who, if they are legally represented, then they should do the bundle. Of course, it gets slightly more interesting when both parties are litigant in person, which happens more often than you might think, because you think about the fact that 70% of people who walk through the real or virtual doors of family law are representing themselves. So this happens quite a lot. In that instance, the court says, or some courts say, not all, I think it's often magistrates that say this, that they will produce a bundle for the parties. Never happens, okay? Never happens. I've never yet seen a magistrate send to each of the parties a bundle. So getting back to the question, because I can easily talk about that, and that's again probably a whole other video. But if the ex's solicitor is ignoring your evidence, first of all, find out, well, is it relevant? Because if you've just sent the other side's solicitors, I don't know, character references or cuttings from the Daily Mail that you reckon might help your case, or 3 bajillion WhatsApp messages, then yeah, probably I might want to ignore that. So just find out, first of all, is that evidence relevant and should it be in the bundle? I have seen scenarios where solicitors, rightly so, would not include the evidence. However, they should be addressing it and saying, well, look, this isn't practice direction 27 compliant, or we're not including it into the bundle for these reasons. By the way, practice direction 27A in the bundle says that contents of the bundle should be agreed where possible. Now, in an adversarial arena such as family court, how many times do you think that bundle contents have been agreed? I've often seen the bundle being used as a bit of a pawn in family court proceedings, despite solicitors saying otherwise. But they are. I get why. Again, it comes back to that whole, if you're producing evidence that shows the other side in a negative light, yeah, of course you're going to want to try and disregard it. However, the contents of the bundle should be agreed, and some of it should be uncontroversial as well, like things like statements, applications, orders. I mean, those things would automatically be put into a bundle. So there are a couple of ways around it. First of all, if you have specific evidence that is absolutely relevant to your case, then you might want to ask the court's permission to have it included. Heck, you might even want to just send it to the court anyway. Massive caveat, less is more here. And there's a whole other video I have done, and heck, I might do it again just to reiterate the point. But you might want to send it off to the court anyway, so they have a copy. There might be some instances, and I've done this before, where if the bundle process is being frustrated that badly, and I've seen this done a load of times, you might want to do your own court bundle. Again, massive caveat with this here, because doing your own court bundle does not mean rocking up with your Tesco carrier bag of life and presenting it to the court. Okay, if you're going to do your own bundle, then it needs to be in absolutely the correct format, and of course practice direction 27A compliant. Often people attach evidence to their witness statement, different to a position statement. So if you have been ordered to do a witness statement, which, especially if you're going to, in the life of the case, you have probably at some point been ordered to produce a statement, and that statement is often a witness statement as opposed to a position statement. So you can attach evidence to your witness statement if it is relevant. Again, massive caveat here, keep it child focused or finance focused or whatever it might be. Keep it focused, keep it relevant, keep it succinct. There's no point in putting 138 pages. I have seen that. But the court don't read it. That's the point. What's the point in putting all this stuff into the court if the court don't actually read it? Okay, giving them War and Peace in the kitchen sink, you need to be strategic. And I suppose that comes back to my first point, is that the rules that you play with in family court are not the rules that you play with in reality. So why are the ex's solicitors ignoring your evidence? It's either not relevant and it should never be in the bundle anyway, or maybe they are deliberately frustrating a bundle process. Maybe they are deliberately doing it. I've seen all sorts, okay? I really have seen all sorts over the last 17 years. So my pro tips way around it: ask permission from the court if there's certain evidence that you want to put in and it's being disregarded. In worst case scenarios, do your own bundle. Make sure it's practice direction 27.8 compliant. And maybe if you're not at bundle stage, you might want to just attach your evidence to a witness statement, and of course that gets sent into the court. I'll also say that when you get to court, they often do housekeeping issues at the beginning of a court hearing. So if you are in that and you are attending court and this is an issue for you, then you might want to just raise this to the court. Don't forget, court hearings are recorded, and you might even want to have something written into the recital of the court order. Let me know if you've experienced this so far. Drop the comments down below. I get this very often, but it's often not a problem until it is a problem. You know, it's not often a problem until you get to court, you get the bundle handed to you on the day of the court, or the statement with exhibits attached to you, attached to their statement, and you just dropped on your lap the day of the hearing, and you're thinking, hang on, why isn't my evidence? I sent this over to them a couple of weeks ago. I also probably caveat as well that sometimes small cock up than conspiracy. Sometimes admin are terrible, and I say that for court admin as well as solicitors admin as well. So drop your comments down below. I want to know, have you experienced this? Is this something you're going through at the moment? Guys, I hope that helps. Check you later.